Hi everyone, it's Grant Abbott speaking. Welcome to this session on the Moat and the Castle. I'll put that aside and I'll take you through exactly where we are in terms of the whole Moat and Castle. Essentially, its base is there to build a structure and a set of systems designed to protect and grow family wealth, as well as estates for the purpose of distribution to bloodline descendants. So when you have a look at that goal, it's quite a significant goal. And really, at the end of the day, as an advisor, who wouldn't want to get involved in effectively providing that? In fact, there's a bit of a typo there. It's protecting growing family wealth and estates for bloodlines. So not with. So when we go down, essentially, it's for me, it's a revolution in advising. Most of us probably, in today's format, what I'm going to do is I'm not going to build the moat and the castle. I'll show you where to go. I want to take a step back and just show you the basics, the broad line basics of what a moat and a castle is, but more importantly, how to protect and build that and grow that family wealth from a high structural point of view. For most of us, and I know particularly accountants and lawyers face this issue, is that we all get sucked into doing, all those really urgent things that come across our desk. And then effectively what happens from there is we get involved in those urgent things and we forget about the really important things in our lives. As advisors, consulting is the core of our game. So we all came into this to essentially to be consultants or advisors or lawyers or accountants. Essentially from that perspective, what we've got is we've got to work out what are we really consulting on? What's our really big issue there? So consulting's the same is when we have a look at it, you can't really provide an all-encompassing set of solutions for a client that really protects a family's wealth, enables it to grow and be passed on the bloodline without getting in the helicopter. And by that, I mean probably the first time I showed the Moat and Castle was in November 2019, well before COVID. So this is a pre-COVID strategy, but it's been enhanced significantly since that. So what it enables, what I've built and what enables me now to go up and have a look at this is that helicopter view. So looking at a client's affairs, looking at everything they've got, whether it's a self-managed super fund, a discretionary trust, whether they've got properties or equities or insurances and wills and all that, we tend to get involved and get down into that, basically the weeds. I mean, when we have a look at it, that overall or overarching perspective, which is where it's really the holy grail for all advising for that matter, everything has been done fairly piecemeal. And by that, I mean the accountants and also the financial planners, from their perspective, particularly the accountants, get involved in trusts and companies, so they know those structures well. They generally know where they are from any particular position. Lawyers doing estate plans, and if you have a look at it, many of your clients have probably got a will that might have been done 10 or 15 years ago or 5 years ago. So that transaction they've had with the lawyer is very short and sharp, and really there's no relationship. I'm going through the process of acquiring a house or buying a house up here in the Sunshine Coast, just a fairly modest house. But even then, I'll deal with a lawyer just on a very small basis. In fact, I probably won't even meet them. Everything will be done just by way of email. And so, again, that interaction is not a wholesale interaction. It's not going to change the life of anyone. And that's essentially what we're looking at doing is with this concept of succession, asset protection, estate planning, is we're going to basically be really recreating people's whole structures from a simple point of view, but from a helicopter view of being there to protect, grow their family wealth and also their estate, and ensure that it is being held there for bloodline descendants. and also will exclude those people they want to exclude it from. Planners, planners are having a pretty tough time now. There's so much regulation. After the Royal Commission, it's just gone crazy, and there was FASEA, now there's no FASEA. So we've got a position there that planners are having a super tough time. And then from that perspective, what happens is that all you do is you spend hours and hours doing statements of advice, and really from that perspective, it's not a huge value. It is huge value for the client, but in terms of your return on the investment of your time, it's getting harder and harder. I think that's the thing, is all those urgent things quite often are not really serious revenue things. And I think that's absolutely crucial. So what we really need is a comprehensive succession, asset protection, estate planning solution, which I'm going to show you. Again, I'm not going to get down the weeds. I want to stick to this at a helicopter viewpoint and show you how to do it simply, effectively, and also easily. It can be done, it has to be done properly. It's not piecemeal, and also tax effectively, which is also a great one, because when you have a look, particularly in an accounting firm, you've got at least 30 to possibly 50% of your clients who really need this solution. Again, because everything's been done piecemeal. And if you have a look at the typical skills analysis to get to a succession, asset protection, estate planning advisor, then we haven't been able to bundle it all together because we don't know what we don't know. And now we're getting in a situation, I see people call me all the time, and obviously come through the support centre at Lightyear Docs, and they're getting confused. When should I use this, or when should I use that, or when should I do this? And as soon as you do that, you start to get lost. So you know what to do, basically, but you don't know how to put it together. So essentially, you're in that state of frame of mind, not unconscious incompetence. You're in the state of mind of being consciously incompetent, which is, oh my God, I know there's a lot there. How do I get over that bump? And then that moves us on to the state of play, being consciously competent, where we really understand what we're doing and how we're doing it, which is pretty crucial. So when we go down and have a look at that, what we need to do is really have a look at the client's desires around themselves and also their family. Primarily, this can be used even for a modest player, but certainly for all your small, medium business clients, it's absolutely crucial. It doesn't matter whether they've got a trust or they've got an SMSF or a family protection trust, because what we need to do is look at what they want in terms of their family, the growth of their wealth, whether it's through business, property investment, share investment, or anything for that matter. And then they need to build their own city. And when I talk about the city, I'm talking about those structures, whether it's a bucket company, which you guys know really well, whether it's superannuation, retail, or SMSF, doesn't really makes a huge difference strategically. But to start off with, it doesn't make a big issue. If they've got a discretionary trust, they've got a bucket company, they've got trustee companies, then essentially what we need to do is look at building that into their own city. So the Abbott family has its own Abbott city, and then build around that a moat, which essentially is a body of water or body of structures designed to protect that city from invaders. And I would challenge you, for those of you who haven't done this, is it's absolutely crucial to do it for yourself. I mean, I know a number of you going down the track, and you probably, find it's a little bit daunting. I'm going to demystify it for you, show you exactly what needs to be done, and then we'll move there. Now, from this Moat and Castle, you're going to find the thing that is the real magic around it is the strategy wizard that I built with my team at Lightyear Docs and also Abbott Mourly. So rather than trying to pull everything together and manage the process on a project management, what we've done is we've pulled all the project management, the processes and the systems and structures all into one strategy wizard. So that rather than picking a bit here and picking a bit there and doing this here and there, it's all in one strategy wizard, which in and of itself is absolutely prime. In fact, I would suggest that particularly for those of you who are on our strategist and our strategist subscription, effectively you get full entitlement to the Moat and Castle. I'll be doing this for every client. You might not use all the features of the Moat and Castle up front, but once you've got the system in there, and I'm going to show you what to do, essentially you can then roll out different strategies over a period of time, because sometimes it can be quite overwhelming to have so many structures and strategy changes just in a period of time. Now, if these are your clients might just say, well, hold on, you're recommending that I'm doing all this. Obviously, if you've done the purpose around it, you've set it up. Why didn't you tell me about this to start off with? And you can simply say, well, hold on. The purpose there is we're now protecting your family wealth across all your city. We're building you a city with a moat. And more importantly, we're going to make sure that in the event of death or divorce or dementia, the money goes where you want it to go. The structures we set up originally were great for tax, and they still are great for tax. But what we need to do is we need to have a broader look at things. Now, traditionally, when we have a look at this total solution, generally, if I build this at Abbott Mourly, because it doesn't take a huge amount of time, but there is quite a bit of negotiating with a client. We charge between $20,000 to $30,000 for that solution. You think, well, hold on, geez, that's expensive, but it's not really, because if you have a look at all the documentation that we've got inside that strategy wizard, that whole project management system, effectively from that one, what we've got is a scenario that if you went to lawyers to build it, if they knew what they were doing, you're looking at easily $100,000 plus in legal fees and probably 6 months to a year in time. Whereas we've condensed it because of the strategy automation, the project management, into a very short period of time. And so when you have a look at it, typically for an estate, if you're looking at a family provisions claim, that can take at least two years plus to complete. And then more importantly, on top of that, you're looking at around about 20% of the estate going in legal fees. And of course, if they can, the longer the fight, the greater the percentage of the estate in legal fees. So what we're doing is we're actually saving the client, protecting them, which then enables their legacy to last for a lot longer. So what we want to do is, if there's one thing you can learn, this year, it's going to be this succession asset protection, estate planning, and more importantly, the Moat and the Castle. Do it for yourself, get involved. If you need to do one or two clients and you want to lean on us at Abbott Mourly, we're quite happy to effectively work alongside you. You'll get everything together. We'll come in and do Zoom meetings with a client, build the whole system for you, and then we'll go on a fee split. That way you'll learn the system, you'll get mentored, your client's going to get a great position, and then we're off and running. But once learned, so again, to go from that unconscious, or we've gone from unconscious incompetence, that's why you're here now, to go from consciously incompetent to consciously competent, it's a matter of understanding, stick to the project management because it's been built with compliance in mind. And more importantly, from there, just keep on completing it. After you do one, it's like, well, that wasn't too bad. The second is quite easy. And I've done about 20 of these now, full ones for clients. So it becomes, it takes me around about 30 or 40 minutes maximum to complete it. So let's go and have a look at all the key components. And traditionally, I'll cover each one of those there. This is a good question. Most listeners don't even know what estate planning is. You're quite right. They just do wills, which is, it's unfortunate. But again, that's that urgency, that matter that we talked about. So let's have a look at the moment. I've got the big red arrow down there. And the reason I say that is we want to try and keep as much as we can from the estate. Now, traditionally, that is the reverse. So that's going against the tide of traditional estate planning with wills, in that essentially, if we have a look at a solicitor doing a will, they'll want money coming from a SMSF into the estate for then distribution. Likewise, all the assets will be in the estate as well. Now, the problem about that is that leads to family provisions claims. You've heard me talk about it quite a lot. Look, there's a huge body of law around it. I even saw in the New South Wales Supreme Court recently, a friend of the testator or the deceased was able to lodge a family provisions claim against the estate and effectively won because their friend, obviously the deceased, had been providing with financial support. So it's starting each and every year, it's getting broader and broader still. And so for that, we need to try and limit the wills. And I want to show you what I do around it so we can still use the estate. But effectively what we want to do is we want to look at the assets sitting in our own names or our spouse's names. And then what we want to do is take the net equity in those assets and then essentially using the protector, put them into a family protection trust. So traditionally, everything has been done on this side. What we're doing is we're moving everything over to this side. So let me go through. So I'll start with a discretionary trust because most of you probably have your own discretionary trust. The weakness there with discretionary trust is it comes around to succession. So when we're looking at succession, asset protection, and also estate planning, the key there for us is going to be that line of succession. You'll find when you do the data capture for the client or send out the data capture for the client, the first question asked is, who's going to be your executor? Who's going to be your power of attorney? And if they're not around or they don't want to do it, who's next? And then after that, who's next? Because essentially what will happen is that gives us a line of succession. And that line of succession is absolutely crucial because when we start building this, obviously, if I have a look at my own circumstance, I had a discretionary trust that I set up, which was the I Love SMSF Trust. And now that has been replaced by the leading member discretionary trust. So what effectively that does is that we have a line of succession there. So for that one, I've got myself as the leading member appointor. Does that make sense? So what will happen is I control that trust. Now, it doesn't matter who the trustees are or the beneficiaries. At the end of the day, the trust structure, it's the appointor, the person who has the power to appoint a trustee. More often than not, we see trust deeds and we regularly upgrade deeds at Abbott Mourly, from the 1970s, from the 80s and the 90s. Quite often the appointor is not around anymore, which means that we need to upgrade the deed and put in that line of succession. And even the ones that we do have, that line of succession is very weak. It might only just be one appointor. So what happens to appointorship in the event of death? So the leading member discretionary trust has that chain of succession of appointors. Now, with that one, we'll have, for example, myself. Next in line will be my daughter, Sophia. So she's 23 years old. She'll then come in and take control of that leading member discretionary trust. Now, if I end up having a fight with her and decide against it, I might well put in, for example, my partner, Tony, along with, for example, my wife, Amanda, as joint leading member appointors. So that one, it's going to be looked after for her, but we've also got Tony in there as well to work together, which is pretty crucial. Now, for that one, generally, you've heard me talk about the successor director solution. What we've done is we've built the successor director solution, which is on the site, and you'll find it in our EPOAs. However, it's inbuilt in the leading member trustee company, which is a special purpose trustee company for discretionary trusts and also the family protection trust. Now, what happens there is the leading member appointor, when you have a look at the constitution of this special purpose leading member trustee company, the leading member appointor is automatically the chairman of the board of that trustee company. Secondly, they have complete veto power over every decision making. So it doesn't matter who's involved there. Really, at the end of the day, in fact, the best person to be there is going to be the leading member appointor as the sole director. But you can bring in other directors. However, what will happen there is effectively the other directors will be able to make the noise and do everything. But at the end of the day, the leading member appointor has the power to veto. Now, ordinarily, if you know the successor director solution, if that leading member appointor dies, then what will happen is a person nominated under the successor director solution will come in and take control of that trustee company. Now, that's not a bad solution at all, but it has its weakness, and its weakness is down at the shareholding level. Because if those shares get caught up in the estate down here, and there's a family provisions claim, the first thing I can absolutely guarantee will happen is that the lawyer or the litigator that is looking at making a claim from a family provisions for their client will automatically prevent that, obviously, a change of the guard in terms of directors. Whereas what I've built into the leading member trustee company is that the leading member appointor should be the only shareholder. So there's no other shareholder in that structure. Now, what will happen is on the death of the leading member appointor, their shares are automatically cancelled, and then new shares are issued to the next leading member appointor. So it has an inbuilt successor director solution. In fact, it's a chain of command is actually built in through that leading member. So again, if we go through, it may well be that it goes from myself, I pass away, it then travels automatically down to Sophia, and now she controls the whole process. She has the only shareholding in the leading member trustee company, etc. Now, alternatively, we could be in a position, as I said before, that we may have, for example, joint enduring powers of joint leading members. So we have to work out exactly what we're going to do there, shareholding. And I prefer simply one shareholding, one director. Again, the tighter the line of succession that we have, the stronger the whole premise. Likewise, when we go to the leading member SMSF, it's exactly the same premise. In fact, I'm doing an article now for Benchmark for their self-managed super magazine. And I'm arguing there that the best way to run a self-managed super fund is simply to have a sole director trustee company. And obviously that would be a special purpose leading member SMSF trustee company. But as many members as is possible, as is allowed under the Act. So for example, with a self-managed superannuation fund, we could have 4 members, and it may well go up to 6 members. But what will happen is we'll have a leading member trustee company, and then there'll only be one director. And what will happen is that director will then have the enduring powers of attorney, and it could well be just for superannuation trusteeship or directorship only over all the other members. The benefit of that is threefold. First off is that it makes the chain of command, the power in that SMSF, a lot stronger, and all resides in one person. Secondly, as an accountant or administrator to the fund, it's easier because we don't have to deal with all these members of the family, particularly if they're not financially responsible. You have to look at if something goes wrong, the tax office will be, if there's an audit, will be challenging each and every one of your members there. Whereas in this instance, it'll only be that one person. They're the decision-making apparatus of that system. And the final one there is that enduring power of attorney, we can just do it solely for superannuation. So therefore, we have a pretty strong issue there. Now, I got the idea, believe it or not, from the Commissioner of Taxation, who's issued a guideline on enduring powers of attorney as they relate to self-managed super funds. And in that, he says that not all members must be trustees. In fact, he gives the example of a couple who go overseas and still retain the status of an Australian super fund, but they provide their accountant with a special purpose EPOA, enabling them to be a superannuation trustee. And as a consequence of that, the accountant is the trustee of the fund, is not a member of the fund at all, and their clients who are overseas are those members. So again, when we have a look at that, and you'll see my 3-part series, it's absolutely crucial to sit down for us from a perspective and say, in this family, and ask your client, who are the people who are really responsible? Who are the ones who can take that leading member role? Who are the ones who are going to be the succession? Because if we get it's the same sort of thing, the leading member here is automatically appointed up in the special purpose trustee company as the chairman and the sole veto power if we want the other people to be directors. Now, I'm looking at one end of the spectrum, but if we've got multi-generations in there, it also makes sense that we might have dad and son or daughter as directors. I'm just showing you one extreme that I pulled out of the ATO guideline on EPOAs, which I will have as part of the package up on our site, along with the recording for this and also obviously the slides as well. So again, with that leading member, it makes a lot more sense there. And also, if the leading member has full control over that process, they can direct where those monies go. And we'll show you a little bit later on that through the SMSF will, which essentially is a set of binding directions, a contract between the member and the trustee of the fund, or in this instance, the leading member, that their accumulation benefits are to be paid in a certain way. There is no way, if I was advising them, that it would ever go into the estate. In fact, it can be, if it goes to dependents, and remember our children are our dependents, and then we can have a look at financial dependents, which I'll be looking at shortly. Essentially, it can go out to them directly as a lump sum, or more importantly, it can be transferred out or assigned over to a family protection trust you'll see on the left-hand side. Or alternatively, we can create a SMSF testamentary trust, which still has benefits for children being taxed as adults under the ordinary marginal tax rates. And it is still a testamentary trust. And the good thing about it, it's not caught by all those recent testamentary trust changes, which is absolutely crucial. Phil, my thoughts were each member must be a director. Yep, unfortunately, Phil, that's a really good question, and exactly the position. And I must admit, a lot of people of that, because it's been drummed into us. Because all we ever do, most of us don't look at the legislation. So what we have a tendency to do, we'll go to courses, we don't do a deep dive into the legislation. So we see there in section 17A(1) of the SIS Act that each member must be a trustee, or as Phil said, a director of the corporate trustee, and vice versa. Each director must be a member of the fund. But then we suddenly go into a completely different world when we go to section 17A(2), because that looks at single member funds. You see, if we've got a single trustee and a single member, then we're in pretty big strife there, because you can't have a trust, and an SMSF is a trust by its very nature. We can't have a trust at law if we are the trustee of and the only beneficiary. So you can't be a trust of yourself. So that section allows us to put in a corporate trustee with a single director, or alternatively have another person in as a trustee or another corporate trustee. So that's the first exception to the rule. The next one is, of course, where we die, of course. Again, our membership is still open. You've just got to be careful on the deed. Obviously, the Light Year Docs deed, which I've built, membership continues on even after death. Just be careful, because most deeds provide that membership ceases, which means that any gains, income, or capital growth accruing on that member's account cannot legally be paid out between the time of death and when those benefits, death benefits are paid. If you do so as an accountant or administrator, effectively the other members of the fund can reclaim that against loss or damages against you. So make sure your deed allows membership to continue on. Now, in that instance, we've got the member who might be continuing on, and the executor can be appointed as trustee or director of the corporate trustee, provided, of course, there's mechanisms in that corporate trustee or the deed to enable an automatic appointment. Otherwise, you're leaving yourself up to the vagaries of the other directors of that company. You can start to see, once we start doing this and bringing other people in, and vagaries and second spouses and children who are estranged, it can turn into an absolute nightmare. So from that one, then we can go on, that's the estate planning. The other one we have a look is that if you are under a legal disability, or you simply, and this is important, have a person's enduring power of attorney, then you can act as trustee or a director of the corporate trustee for that member on their behalf. It's like a successor director solution down the SMSF. So again, this whole thing about it is, it's quite interesting when you have a look at it, Phil, that in terms of our SMSF knowledge, we can start off with unconscious incompetence. Remember that skill level, which is essentially where most of our clients are. We go up to conscious incompetence and then conscious competence. Now, the fact is that we're learning now, and again, don't take my word for it. Have a look, a really deep dive on the Commissioner's ruling on EPOAs. I mean, that's effectively where I got the strategy from. We can then take that, and then that takes us to the next level. It enables us to open up a lot more strategy solutions. And more importantly, as our clients are getting older and older in the system, the potential dementia, etc., the last thing we want is in their decision making. And that might be the case. For example, we've got John here, John Smith, who is the leading member, and he's there with Max as well. So they're both directors of the corporate trustee. Now, what will happen is John's the leading member, he passes away, so his shares will go directly from him to the next leading member, which is Max. So there's continuity in that whole provision, in that whole strategies there. So when we have a look at that and we move over the other one, we've got our discretionary trust, which typically is going to be our business entity. So we can upgrade our discretionary trust to a leading member discretionary trust if we want, and also the leading member trustee company. So that's a process in itself. We've got the bucket company, and I'm going through a change to that now to also make that a leading member bucket company as well. With our SMSF, we can go through the process of upgrading our deed again to the leading member and leading member trustee company. But can you see what's happening is the same leading member there is going to be the same leading member there. Now, in the succession, when we've got John going to Max, then the next successor leading member in the discretionary trust is going to be Max. The next successor leading member in the SMSF is going to be Max. The shares in the trustee company will pass to Max. Well, they don't pass, new shares are issued, same there. Max will also be the executor of the estate. Max will also be the power of attorney for John. So essentially, once John passes or becomes incapacitated or becomes too old to do everything control of this whole family city, the Smith city, effectively passes down to Max, which means we've got to be very careful on that line of succession that we choose the right person. It's exactly, unfortunately, when we have a look at the British royal monarchy, it automatically just goes down to the firstborn male heir. So that doesn't seem to me to make a huge amount of sense going down the track. But essentially, when we look at that, now over the far left-hand side, our leading member discretionary trust may well be a business. So all this stuff which is sitting here in our own names, etc., we want to keep it in our own names. So, for example, it's a principal place of residence, we want to retain that exemption. If we've got margin lending on shares, negative gearing on property, assets like that, gold, etc., in our own name. We want to still keep that in our own name, but we don't want it set up for the vagaries of the estate family provisions claims. Otherwise, if we've got one child or estranged child, brother or sister, you never know who can make a claim. And they're getting broader and broader, as I said. So what we can do is through the protector, we do a gift of the value of those assets, the net value of the assets. The assets don't cross the red line. So there's no capital gains tax or stamp duty. We get the equity or the net value of those assets, and then effectively they are transferred over the line into a trust. Now, when we have a look at that, the trust is going to be the family protection trust, because we don't want to transfer the equity over to the leading member discretionary trust if there's a business in there. Because if the business goes down, and you'll see it's a transfer of equity over or net value, and then there's a loan back to this family. And by lending back to the family, they've still got all their assets, but effectively they have no equity value in them. So in that instance, what happens is we don't want to put the good equity or the good value in something that might end up failing. So what we do is we could set up a separate family protection trust to hold that. And then likewise, we can gift assets across there. So we could run a protector, because the bucket company shares are again going to be sitting on this side if they're not inside that discretionary trust. So again, the value can be put over to the family protection trust. Now, over time, if you want, you can, there'll be a loan outstanding, which I'll show you a little bit later on. But if we've got an asset there, there's no capital gains tax or no stamp duty, such as shares, we can transfer the shares directly over to the family protection trust, and the value of that will be offset against the loan. So we can end up putting more and more of our assets there over time, which is absolutely crucial. So I've just got a couple of questions from my good friend Kush. The leading member SMSF was single director. On death, the executor becomes director. If there are other members, do they have to be appointed as directors? How does the executor act for the other members if he does not hold the EPOA for other members? So if we have a look at it, the leading member with a single director, that's a really good position there, Kush. And I think you're going to understand my suggestion on this one, is that if we have a look at it and then we consider the position, is that there may be 3 or 4 other members there. We need to have that line of succession of max, so that when we have these people with their EPOAs, can you see that, who are going to be members, the answer to your suggestion is, in the event that John Smith dies, the next person who's going to be the power of attorney is automatically going to be Max. So then Max will hold everyone else's power of attorney. He'll be in the leading member and will be the sole director. So again, you can see the whole skill is getting that line of succession, because I've thought about this. You can see how seamlessly, as soon as John has his last heartbeat, his shares in the trustee company for both discretionary trust and member both cease. The next succession appointor here and also the leading member transfers to Max. Everyone else's EPOA would have Max as a successor, so you need to build that in, and then essentially you are off and running. Now, there doesn't need to be an appointment of an executor, and why is that? Because guess who the executor is? It's going to be Max. Does that make sense? Now, if Max is not alive, then we might have the next successor being Julie over here. And again, so that goes down. So what we're doing is we're putting a really tight control in that whole position. We're building a moat so it can't be challenged. So hopefully that makes sense there, Kush. From George, is there a situation with children from 2 different relationships? Can you make a trust a fixed trust to allocate the assets controlled to children from each relationship? With a discretionary trust, effectively you can, but again, it's going to be it's a really good question, George, is how do we set these up for different families? Because these are discretionary, my tendency, and it may not be the best one, is remember what we're looking at is we're looking for bloodline, and blended families don't have bloodline. So my suggestion is that you would build these quite separately for different families, if that makes sense. But it doesn't matter. I mean, at the end of the day, you have to take your client through it and let them get that aha moment, because you'll find that, let's say we've got John Smith here, we've got Julie there, and we've got Julie's bride-to-be, Bob, who's come in with a couple of stepchildren. So Julie hasn't got any children. Does John want to see money go to Julie and then find it goes to the stepchildren as opposed to all the other bloodline? I don't think so. So again, your issue is finding out who's in that city. Does that make sense? If we go back, who are the people who are actually in that city are going to be protected by the moat, and who are those people out? Again, that line of succession is absolutely crucial. So for David Ruthenberg, can a brother and sister, no parents, gift a personally held property, no debt to a family protection trust for doing a development on that property? Absolutely. So what we can do is, the issue about that is, David, if we look at that, and I'll take you through, if the property is sitting between sister and brother here, and we move that property in, then we're up for capital gains tax and stamp duty. So the different way of doing it, and just let me play with you here, is ultimately if you're going to buy the property, you would buy probably in the leading member discretionary trust. And the reason I would say that is that there's potential developments fail, and you don't want to put it into your good family protection trust. So what you can do though is you can do the development outside between Julie and also Max. Obviously the tax consequences are going to be much the same. Alternatively, you could even do the development with those parties in partnership with the SMSF or the discretionary trust. But what will happen is the growth in their net equity in that total development, that will be transferred over to the family protection trust. Now, it may not be huge to start off with because there'll be bank loans, but as it goes and over the project, you can transfer more over. So that gift loan back strategy can be enhanced all the time. And I'm working on a document now with Tony to make sure that it grows over time so we can go back and readjust the protector, much the same way as we do with Div 7A, which is pretty crucial. So Sean Costello, and it's good to have all these questions. And again, put these things up because these are the stuff that we need to look at. I know these are very in the weeds question, but they're also important. If you have a property that has no debt against it and you give the equity to the property protected trust, you're taking a mortgage. For wealth building, you want to use that equity to grow your wealth and acquire another asset. How do banks look at this? Well, effectively, that's a really good point, Sean, is if we've got an asset over here and it's growing and we transfer it over here, we're doing it for asset protection, family provisions issues, there will be obviously a loan back and a mortgage. So the first mortgage will actually be in the family protection trust. Now, what you'll need to do, obviously, if that's the case, and you're looking at borrowing equity there from the bank, essentially what you'll need to do is you'll have to rearrange the borrowings because, in fact, we may pay down that borrowing or reduce the borrowing and go second mortgage in preference to the first mortgage from the bank. Again, these are just cash flow issues and the way to do it. There's some excellent articles sitting up on our strategy center on each state, how second mortgages relate to first mortgages. Quite often, there's no need at law for a second mortgagee to tell the first mortgagee or the mortgagor to tell the mortgagee around the first mortgage, but you'll find that most bank documentation does require you to do so. To date, and I may be wrong, but I have never seen a bank worry about it because they make sure they get security up the wazoo anyway, and second mortgage is effectively there. There's also a really good article there that I put there in terms of why do a registered second mortgage versus a caveat, and that's It's pretty crucial because obviously the caveat doesn't stand a test over time. So as the net assets change over time, how often should you do the loan documents? John, I would do them. And can I just say something on this one? And this is really important. I was talking about it with someone yesterday, is when we build this solution, we need to go to the client. Ideally, remember I talked about it being $20,000 to $30,000 per annum. Well, each year, particularly if you're the accountant, you're going to have to do obviously sets of accounts. You're going to have to do administration around these structures. The family protection trust, if there's no assets in it, it's just simply gift. And then any loan interest is capitalized to the end of the loan, then there's really going to be no income going through it if it's on a cash basis taxpayer, which it would be. So what we need to do though is we need to make sure that our family there, that if there's any change in any of the relationships here, that they notify us straight away. If there's even an inkling that these two aren't getting on, they need to tell us straight away so you can make appropriate changes in all of this documentation. Likewise, with the loans, etc., you're going to go through that process, John, of finding out what their net equity is each and every year as part of the process. So you've also almost got, it's an ongoing process for this for as long as they live. In fact, it's going to be longer than you live, because remember, we've got automatic passing from there down to Max. And if Mac's not around, it goes to Julie. And then we can always change that over a period of time. So from Naomi, how can the other children be protected for their inheritance when you only have one child as the next leading member and executor? That's a really important one, Naomi. So when you come through and we've put all of this, when you've got the next leading member, and this is a really good strategy, and I'll talk to you. When we've got the, obviously the discretionary trust, the next leading member is obviously the appointor. So we can have the other children as directors of those trustee companies if we want. Obviously, when we go down that leading member SMSF, if we've got other families coming in the second or third generation, they may well want their own leading member. So what we can do is, if we've got this family protection trust, we've got no assets there. What we did recently, there was a client, and I think you've got clients like this, Naomi, up in Port Lincoln, that essentially a large part of the farm is going to go to, well, all the farm is going to go to the child that works on the farm, which, for example, in this instance might well be Max. And then Julie may end up with a cash stipend of $1 million. So how does that work in practice? Well, if the farm is outside sitting here and we've transferred the net wealth in there, and then there's a loan back. So on death, if you think about it, work it through. So Max is the executor. Max is also the going to be the family protection appointor, which is like the leading member appointor, and also the sole director. So what can happen there is we can have a will that gives $1 million to Julie, but it's facilitated in the loan agreement through here, if this makes sense, Naomi, that loan that is being offered to the estate, because essentially it is, on death, that loan will be called in to the Family Protection Trust. An amount of $1 million can be set aside for Julie and her family if you want to do it through a testamentary trust. And what it'll do is that $1 million will come off from the loan proceeds. So let's say the loan is $3 million from the estate. Remember, John's died, and it's going to the trustee company. Then in that instance, what will happen is only $2 million will pass over to the trustee company by way of asset transfers or cash, and that other $1 million will stay in the estate to Julie. But it'll be on the basis that Julie makes no family provisions claim. So you can do that, but if she makes a family provisions claim, then the loan will end up in that family protection trust. So again, we get around it that way, if that makes sense. So it's a good question. How do you find in practice people without children leave their assets to? Quite often, that's a really good one. It's nieces, nephews, brothers, and sisters. Failing that, it could end up going to a charity. And of course, I'm more than happy to help along that way if you want a beneficiary or two. So over here, we end up with really nothing in the estate. But again, it's this fluid business. If something changes, so Julie falls out of favour, and then we've got that will that says there's $1 million there to go to Julie. But then we've got the Family Protection Trust where the loan agreement says that that money is to be paid on the death of John over to the estate. Effectively, what we can do is we can recalibrate that loan agreement and effectively take it out of Julie's hands. So again, this is a very strong structural position. And of course, there can be no family provisions claim on that. So what are the benefits? First off, if everyone sees it's a helicopter view, we're looking at taking our client's city and then building the structures around it. It's not that difficult, believe it or not. So it's an all-encompassing solution for the client, and it looks at every structure. And the whole idea there is to protect and grow a family's wealth for their bloodline. And at the end of the day, if you said to your client, look, we've been using structures in the past that are great for tax perspective, and I want to keep those structures from a tax. But now, and I'm going to show you a little bit later on, now we've been looking at, I've become accredited as a succession asset protection estate planning advisor through SMSFs. What we've learned now is how to take those structures and ensure that they're to protect. And remember, this is about protection and growing a family's wealth for their bloodline. Would that interest you? And I can tell you 100% that people would say yes, because at the moment, none of the structures you built for clients are really protecting their bloodline or asset protection. So that's the first benefit. The second one was when we go through it, whether it's the protector itself, whether it's upgrading the discretionary trust to a leading member, or in just putting in place a simple leading member trustee company. Once you do that, you don't need a successor director solution. So all of these things are embedded into the documents itself. A leading member SMSF, an SMSF testamentary trust. Each one of these are $3,000 to $4,000 to $5,000 solutions in their own right. And what we're doing through our project management strategy wizard, we're building them all together. So they're highly valuable. So when you're charging $20,000 to $30,000, you don't have to do that. Roll it out if you want every month, roll out a new solution to the client. You can do it all up front, roll it out, and then charge, $3,000 to $4,000. Or then put them on a retainer, $3,000 a month, and over the year you're going to build the solution. Although effectively you'll be able to do that in like 30 or 40 minutes anyway. With the family law action, obviously there is, when we go back in this instance here, with the family law, we may have Max, who's suddenly getting divorced from his spouse. John's passed away, Max is in there. In that instance, what we'll need to do is we want to get Max out of there as beneficiary, appointor, and trustee. The easiest way of doing that, of course, is to simply resign, and then that all flows over to Julie, who's the next successor. So his shares in that trustee company, or both of them, go to Julie. If it's a discretionary trustee or family protection, he's no longer the family protection appointor. He's excluded as a beneficiary, and also it can be put in place as trustee, but doesn't make any sense. Of course, there has to be a good agreement and arrangement between there. So that's a matter of discussing with that particular client. So family law, there's quite a lot of papers on attacking how family lawyers attack trusts. The main one I can tell you is the first thing that the family lawyer will do in this instance will make a claim to the family court to essentially lock down that trustee company and lock down that trustee company as well. So they won't be able to do anything. Whereas what we do is, if we know it's going to happen, we get them out of there straight away. All they have to do is resign as family protection, like leading member, family protection appointer, or leading member, and then everything's done for you. So it's going to be too late. Does that make sense? Because the family lawyer is going to want to attack that city. And without this, there is no moat. So in fact, the city hasn't even got any ramparts. They just walk straight in and can start to attack. And the idea about that, and I can tell you from family law, family provisions law, is to create as much problem, as much friction for as long a period of time to wear out the other side. Now, it's going to obviously create a huge amount of work in terms of the lawyers, which they're happy about. But by wearing out the other side, it locks all of these things up. And I've seen banks almost foreclose on property sitting in here because of that wearing down. If solvent at the time, so part of the protector, you're obviously going to sign a solvency certificate. If you give that money over to Family Protection Trust, there's been nil consideration, so 4-year rule applies. However, if you're a solvent at that time, it just makes it so much harder each and every day for the trustee in bankruptcy. Now, if you're not solvent at that time, then a protector's not going to be of use to you. You're better off having a chat with Michael Jeffries and Rod at Venom Optimum, and then they can come in and help. The main one there is, when we look at it and we had put that moat around it, again, which is easier, like a castle with all of these structures and gold just hanging out there with a rampart that's open, you can go and attack it, or these fortified castle with all the moat. You see, at the end of the day, a lawyer's not going to work for nothing. They're going to want a retainer. So if you've built up all this structure, I can tell you, whether it's a family provision or whether it's family lawyer or even the trustee in bankruptcy, it's going to cost a lot of money for them to try and prize their way or start to, swim across that moat, get up the rampart. And by that time, you'll have oil, you'll be able to pour it on top of them. So from their perspective, they've got to think once, twice, 3 times whether to attack it, because that's a lot of money that they're going to be leaving on the table. And if they can't guarantee, if there's nothing in the estate, how is their defendant or their plaintiff going to make a claim? Who's going to get paid for it? So unless it's a huge estate and you've got litigation, then actually it's a good question, Chris. Unless you've got a litigation funder, which I would say a litigation funder's not going to go through, try to attack a moat unless it's a really huge estate. Chris Becks, can the resignation be automatically triggered by a divorce and a family agreement? Absolutely. So that's a really good position. My preference, though, Chris, is that if we get a wind, and this is why the moat and the castle, we're protecting the family wealth and growing the family wealth and protecting for the bloodline 24/7, 365 days a year. So you need to be talking to them and saying, look, if there's potentially an issue, you need to come to us so we can make changes. And in the documentation, particularly the moat and castle, it's open-ended. So you can go and make changes on the fly, reconstruct the whole thing, write out Julie, for example, if she becomes estranged, write her out of the whole equation really quickly. In fact, you'd be able to do that within a day or two. And how fantastic would that be to offer those solutions to clients? Because otherwise they're just going to be, the stress is stress. And when there's something like that happening in the family, it can be very stressful. Again, as I said, one of the best things here is to make sure that you do the moat for yourself as well. So let's go through. I'm sort of running over time a bit. Let's just go through, and I'll go through this and then I'll show you. So I'm going to be about another 20 or 30 minutes. I'm really sorry I've talked a lot, but I wanted to make sure you got full value out of this. So when it comes to the moat and the castle, the first thing is to get the client data capture sent out and back, because that talks about that succession, talks about what they want to give to their children. It looks primarily at the estate and enduring powers of attorney, successor director, solution, etc. So from that, it gives you a really good understanding of the client. The main thing is, when we look at it, you're going to need to get all the trust deeds and company details. So most of you would already have that. We're finding for a lot of our guys that they can't find deeds or they're lost deeds. So at Abbott Mourly, we've got a lost deeds solution there for you if you want that. Look, feel free to jump off this call if need be, if you've got an urgent appointment to go to. Again, sorry, I just need to get this into your brain. This will be recorded and will be available this afternoon. So I'll send it out with these slides. So make sure you get all the trust deeds, etc. Get the client to do the data capture. I'll show you where that is. That's sitting up on our strategy center, which you've got too. You want to list down all the common parties. So you'll find that I'm going to show you. So the common parties are basically going to be the people who come up at least one or more times in the Moat and Castle. So that would be Max, Julie, their kids, John, Sally Smith. So that's John's wife. We want to go through the whole process of executors. We need obviously all the corporate trustees as well. These are all common parties. And we even need to have your firm in there as well, because essentially what we're doing is we're writing you into the wills and all the documentation, the protector, SMSF wills, as advisors on death, divorce, and also dementia as well. So the question is, do you want a protector? So my question there is, if there's a 5% chance of a divorce, a family provisions claim, or litigation or financial problems, then you want to put a protector. Every time I hear that we've got a daughter or a son who's a lawyer, if someone's estranged, they're not getting on well with a daughter-in-law or son-in-law, essentially I always go the protector. It's again, you're better off being safe than sorry. And if you want that testamentary trust built in, because obviously you can't do a testamentary trust from the family protection trust, you do that through that adjustment. Remember that loan adjustment, it goes over to the estate. For Julie, remember we did that, and a testamentary trust can be created, provided, of course, she doesn't make a family provisions claim. Enduring power of attorney automatically puts in the successor director. But if you've got leading member, you don't have to worry about doing that anyway. Discretionary trust, we want to change to leading member with that line of succession. Get that line of succession 1, 2, 3, even 4 if that's possible. Because remember, the companies you're doing, there's no rule against perpetuities for them or the SMSF. So you want to have that long line of succession. And one of the first questions you need to ask a client each and every year, is this line of succession you put in place still valid? Because I can tell you things can change like that with your family on a heartbeat, on a testimony to that. SMSF change to the leading member, again, the line of succession. Whether you want to go down that track and just have, for example, one director and all the members, definitely as they get older, keep the people inside the fund, but don't just leave them as members without having to have the rigors of trusteeship. And you'll see in the next article that I have coming out in Self-Managed Super Fund magazine, it's quite, do you mean the rigors of trusteeship are quite considerable? And you know that. The trustee or the commissioner says that each trustee is responsible for every action. They can get liable or for administrative penalties. So why not just have one? Just doesn't make sense. The SMSF will was for accumulating super only with a testamentary trust. We can then build in reversionary pensions, which are multi-generation. So it can go from there, it can go, if we want, it can go from John to Sally, and then it can go to the grandkids. Unfortunately, I can't look after the dogs. I probably can through a bequest in some way, shape or form, but we can transfer that pension on. The problem is if it goes from John to Sally, then to Max, Max is an adult, he can't take the pension. So he could then convert that, put it into a family protection trust or into a SMSF testamentary trust if he wants to do that. So either way, it's fine. But if he's got grandkids, so I've said these are the stepchildren, so they wouldn't pass. But if he had his own bloodline children, then it can go from from John, Sally, and then on to the children, provided, of course, their financial dependents. So the discretionary trust would change or reversionary. The wills, in the will, you've got limited use unless, like Naomi was saying before, you've got children outside who need to be looked after. So therefore, you can start to use the testamentary trust. So when we come down to it, I'll just bounce out of here and I'll just go and show you for this one. So what I've done is I've got the site open here. You can see, isn't this exciting? This is what Grant does for a business. Just looking at the non-arm's length rules, very exciting. So I've got the site coming up. I've got the Lightyear Docs demo. I've done my document storage. I go down into my vault. I built one before for our October strategy day. Now, for those of you who came to October Strategy Day, I showed a very simple EPOA and will automation, and I'll be looking at this in detail on the 1st of February at the Change GPS Day. If you haven't signed up for that, that'll be a great day. We also looked at the estate planning package, which is the Moat, but that's heavily dependent on just SMSFs. So that's a good one for wills, SMSFs, and estate planning. But as soon as you've got discretionary trusts, effectively this is where you are. The Moat does have the protector. So what I've got here is I've got the Moat and the castle. And I just generate that now for us. So that's just pumping up there. So thank goodness my speed of my internet was crap yesterday. So you can see there up on the site that effectively we've got the document set up. Now, I just want to take you through. These are the common parties. So this is the most important part of the whole equation. So remember I said we want to put John and Sally, obviously. John and his spouse. In this instance, I've got Janet, who's a disabled child, because you can create on death for Janet, both through an SMSF or alternatively through the estate. You can create a disability trust for that one. We've got Max Smith as the son, Max's 2 children. Anyone who looks as though they're going to get a bequest, there's no problems about putting more in there. So you want to put as many people in there, brothers and sisters even. So then we've got the Smith Trustee Company. So this is for the discretionary trust. You can start to see when I go through the Moat, the castle also upgrades discretionary trusts. We've then got SMSF nominees, which is the trustee company for the super fund. You've got your details, which are Jones Accountants there. We've got the Smith Family Protection Proprietary Limited. So I know that I'm going to use the protector. We've gone into your docs and set up that family protection, Smith Family Protection Proprietary Limited, which will act as a trustee. John Jones, who's going to potentially be executor, who's just a friend. So it's just a fail safe or the breaker there. And then we've got our Smith Bucket Company as well. So you've got all those structures. Remember I showed you in that picture. We've got all the structures there sitting there, and they're all sitting in these common parties. And the more I cannot tell you, the more you get in the common parties, the easier it is, because things change over time. Rather than adding, put as much in. And then we go down the documents. So in these documents, do you want to add the protector? We go yes. Now, bearing in mind, when I go down the track, I might not want to do the protector straight away. I might just want to do the enduring power of attorney and the wills for the client and then do the protector in 2 or 3 months. But it doesn't matter. When you're using the Moat and castle to start off with, you'll still go through the process of doing everything, doing the whole kit and caboodle, that complete protection and all that. You don't have to give it to all the client at once. I'll talk about the drip feed a little bit later on. So we're going to add the protector. Now, we'll still go through with the protector. Whether the client wants it or not, it's immaterial. We still want to build it. We put in place our enduring power of attorney. Now here, they've got a discretionary trust. So John's got one. So we're going to upgrade it to the leading member discretionary trust, and we're going to upgrade our trustee company to a leading member trustee company. And essentially all that happens is we just need the shareholders get together. Now, mind you, in this one, if we are going to go to the leading member, we may well have had John and Sally as the shareholders. I'd cancel Sally's shares and then just make John the sole shareholder, again, for all the reasoning we went through before. What we've got here is you can either upgrade your SMSF, but we're upgrading to a special purpose corporate trustee of an SMSF and upgrade the SMSF deed to a leading member. So the same process. So your clients can be in a position of having all these structures, and you're just simply overlaying the helicopters coming down and providing that moat and that level of protection. A family allowance agreement there, and also the dependent declaration is it's like a set of crabs. From the family allowance, John would provide a family allowance to Max and his family, and Julie and her family. That money would then go down into a pot, so be received by Julie for all the family. for their lifestyle expenses. Doesn't matter how they use it, whether they use it for the kids' education, holidays, day-to-day living expenses, but it's important it's a monthly allowance, because that then will substantiate, we can't guarantee, but it'll substantiate financial dependency on the deceased, which is John at the time of death. And likewise, the reverse, we have the other side of the crab, is that we've got John putting a dependent declaration to the trustee of the fund, effectively that all these people are his financial dependents because of this family allowance. Again, I've changed that. You don't need to just use this for SMSFs. You can also use it for retail and industry-based superannuation funds. SMSF will there, obviously you can't use that for retail or industry. Again, with that one, we've got the ability to do SMSF testamentary trusts on that. Account-based pension with reversions, so that's that multi-generational issue then. And then we've got our last will and testament. So we can either build it with testamentary trusts, or we can just do the last will and testament, and then we've got all your details there. The reason we do that is effectively there's a letter prepared out of this project management or this strategy wizard that says that basically you've created all of this, particularly around the wills, etc., based on a data capture provided by the client. So again, that data capture is the first point. And you can see here when we go through, we'll go through the documents. When we've got doing a protector, would you like to establish a trust? Well, yes, we would. But remember, we've already got the family protection company there. So we're going to go through the process of doing a trustee. We do a solvency certificate. We do a deed of gift of the net worth over, which is established through the promissory note, which is payable on demand. That's then lent back with a mortgage deed to secure it. So what we need to do is we just simply go through the process there. Enduring power of attorney, just to show you how simple it is. I've got John Smith, and obviously he's the principal. The attorney there, I've got Max. I could make a joint, but what we're going to do is we're going to make it effectively Max, and then it goes to a replacement attorney. It's not a joint one, but we want to have the second replacement. So here's John Jones, a choose friend. So it could well be, in my instance, it could be Tony Anamoulis for that one. Then we go down to the next one, the power of attorney. Do you want them to act as your attorney as a replacement director? So that's that successor director solution for your EPOA. And you can build in the successor director, but if you've got leading member, you don't need to do that one. When's it going to apply? Well, upon signing the document. That way you can put in that EPO director solution for the self-managed super fund, rather than having to wait for a medical practitioner. Do you want to revoke? Yes. And so you'll just go through and complete that for the client. Then for the successor director solution, again, you've got all these trustee companies, which would be okay. But remember, if we're using leading member, we've already upgraded, we're not going to do that. So it doesn't hurt actually to do a bit of both. So when we have a look at the trustee companies, we've got SMSF trustee, the SMSF nominees, the bucket company as well, Smith Family Protection. So therefore, we've got the current director name, etc. So again, your enduring power of attorney and that succession line will follow there. So that does all my EPOA. I won't go much further. With a discretionary trust, we've got an existing one. So I just have to put the name of the trust, when it was established. That's again, you need to have the trustee, the date of the deed of variation, which state it's in. You can either put in a charity if it vests. If it's in South Australia, you don't need to do. You look at the deed to find the rule number that allows you to vary the deed. Has it been varied in the past? And then, so what we do is then we go into the meeting. So it's a company constitution. So I'm down into the trustee here. So we've got the Smith Trust nominees. We then go to the leading member appointor, and we've got John Smith there. Second leading member appointor, we've got Max Smith. And then third leading member appointor, we've got John Jones. So again, you can start to see that succession, and that'll flow through. Potential beneficiaries, is there a company? We can put in the bucket company if we want there. And then essentially that's my deed, which has been upgraded. As you can see, it's a very quick process once you've got the succession. And then you can do the same thing with your SMSF. Then you do your family allowance. So the family allowance here is who's the provider? Well, it's going to be John, or you could make it, for example, a couple if you wanted to. The recipient is the family. So this is the Max Smith family. Max is the recipient. You can see here we've got all the addresses already set in place there. So that picks that up. What's the allowance here? It's $1,200 a month, and that carries on. Dependent declaration, we've got again John Smith. He's declaring Max Smith as his dependent. He's Ben and also William, and then the declaration of dependency meeting. Then you got your binding death benefits, or what we call an SMSF will, and it continues on. So we go down, we've got the protector at the end, and so on and so forth. So again, once we get that and we start building it in, we can really use this as our project management tool. I would say that really for every client, it's worthwhile going out up front and then coming in and building the whole thing based on their data capture. And again, if you don't know how to do it or you want our support, again, we can provide that for you at Abbott Mourly. So that's A-OK there. And have a chat with Tony. Are you there, Tony, at all? Or? Okay, so Naomi, why do you do assigning for the EPOA rather than incapacity? That's so that we can, goes back to that following, is that with the incapacity, we can then act as a replacement trustee or replacement director or successor director solution. So we want that EPOA to apply straight away, because our EPOA doesn't have to apply on incapacity. That's only one circumstance. In fact, there was a case on it just recently in New South Wales that talks about, it was held in 2020, I think it was November, that held that if you want specific things in the EPOA, you can. For example, we can enable our EPOA to do an SMSF will or a binding death benefit nomination if we want, but it needs to be embedded specifically in that EPOA as a special power. Now, when we do that, obviously we don't want to ensure that you have to wait for medical, because once medical happens, then it's virtually all out. It's better to have it applying straight away. On your resource website, do you provide a list of terms and their meanings like successor director, financially dependent, etc.? John, not at this stage, but I am writing a book on succession, asset protection, and also estate planning with a number of other authors. And so we'll have a good what is it, a suffix or a dictionary there. So we'll put that in there. So that's a really good suggestion as well. Look, I won't go through anything further, but essentially when you have a look at it, the finished document is quite amazing. So let's go back to just the PowerPoint slides just to finish off. So from that perspective, there are a lot of documents there. So as you can imagine, you might just want to send out the EPOA to start off with. You might then want to send out the discretionary trust upgrade to a leading member trust upgrade, within 3 or 4 days, so that there's this ongoing information coming to the client, which is absolutely crucial. When we have a look at that, because you can't send it out, I've tried it a couple of times and really it doesn't work. It just blows their mind. Determine the worth and value. As I said before, when you set your price, you can do it per document. You can do it over a year as a retainer. Alternatively, you can just charge up front and do the whole thing over a month. So it becomes a month-long project, which is what we tend to do at Abbott Mourly. But, for the family provisions claim alone, essentially when you look at, $2 million estate is probably going to be burdened down with at least 2 to 3 years of stress on everyone and $400K in legal fees. Essentially, the weight off the shoulders is absolutely crucial for your clients. And when you go in, you see it all, there is a huge weight on the shoulders. In fact, I did a bit of work for a lawyer recently, and their comment back to Tony and myself was, look, I've been and seen a whole lot of different people who do different bits of this, and I've been looking around for a while, but no one's done the whole thing and put the whole package together. And I think that's pretty important. One of the important ones is to give you authority, confidence, and accreditation to put up your wall. We will be doing a succession asset protection estate planning advisors course, and that'll be available in March 2021. So watch out for that one, because the first one's coming through. Obviously, there'll be an assessment, but certainly it's not going to be as tough an assessment as it will be down the track. But again, you don't, as you can see, you don't need to get in really the nitty-gritty of a lot of the detail, because it's more that high level, that helicopter point of view. And look, I'd strongly suggest that you do the Moat and Castle for yourself. Now, if you'd like us to mentor, just either contact myself or alternatively, just contact Tony. So Tanamoulis at Abbott-Mourly.com.au, and we'll be able to take it there for you. I know I've gone over time and I apologise, but what I'll do is I'll record this. I'll send that EPOA ruling, because there's been a bit of question. I'll send you out the slides as well. And so just use this. If you see this once or twice, you're going to get a really good feeling. It's not a in the weeds sort of argument. It's just a matter of getting these structures and building them properly. And that our project management tool, that strategy wizard, does it all for you and does it very quickly. For those of you who are already strategists and licensees, go ahead and just play around with it. It's fantastic. Anyway, it's Grant Abbott signing off, and thank you very much for your time. This is a whole new revolution in advising.